like to welcome everybody tonight to the Leeds Planning Commission meeting on June 6, 2012. If we could start with the Pledge of Allegiance. Diana should ask beforehand if you want to repeat that.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
We can do a roll call starting on my right.
Ready to go.
Diane Bergen.
Sarah Luttrell. And Councilmember Doug Bergman called and asked to excuse the cards coming in. Declaration of abstentions and conflicts by planning commissioners, if any. Once again, I'd like to reiterate that I have no conflict with anything on the agenda, but giving the crazy rumors going around town and the unfounded accusations out of an abundance of caution, I would declare a conflict of interest. As it relates to the road master plan, even though I do not have one, I do receive financial benefit from the Sterling family where my daughter works for them. And I have used, do use, and will use many of the consultants that also Grapevine Wash uses. And but I do not have anything to do with that project. I do not have any ties to it. No financial benefit one way or the other. In fact, I didn't even look at the project or know anything about the project for over 2 years since I got off the town council. Okay, tonight's consent agenda, the minutes for May 2nd, 2012, Planning Commission meeting. I noticed an incomplete sentence and a couple thoughts that weren't exactly finished. And so to get these more accurate, I propose that I would make a motion that we table the minutes so that we can complete the incomplete sentence and a few of the thoughts that aren't finished.
Well, while we're on that subject, I was looking at it, and I don't know how important it is to make sure all the T's are crossed and the dots are placed, but and I'm sure it was my fault because it was kind of confusing at the time. But it shows that I wasn't here on March 7th, and I was. I was not here on April 4th. I was not here for the April 4th meeting, but I was here for March 7th.
So where it says March 7th, change that to April 4th?
No, where it says March 7th, that I
It's pointing out the meeting that you were not
I
at,
just
just
looked.
correct.
Oh, okay, yeah.
Okay. Any other discussion items? There's a motion on the table. Does anybody want to second it?
I'll second it.
All in favor?
Aye.
Aye. We need to have a motion to approve tonight's agenda.
Make a motion.
I will second.
All in favor?
Aye.
Aye.
Aye. Are there any announcements? I would make one announcement. Longtime resident Mr. Eager passed away in the last 2 weeks. And so condolences to him and his family.
Dwayne.
Was it Dwayne?
Dwayne Eager. Dwayne Eager.
So anyway, we wish his family well. Move into the public hearing portion of our agenda. Resolution number 7, staff report by contract planner regarding ordinance 2012-04 amended and restated, supersede of chapter 21, subdivisions of the land use ordinance 2012-01. Mr. Nicholson.
Okay, I didn't prepare the staff report, but I'll go over it. I'm familiar with the issue, and I think it was probably drafted by possibly the mayor of Fran. I think straight in it. It was the request has come from the county recorder and county treasurer, and it's gone out to all cities within the Washington County to have the county treasurer have a signature block on final plats before they're recorded. And the purpose is to make sure that past due taxes on the property are paid before that plat gets recorded. Okay, that's kind of the overview. Let me just read this a little bit from the staff report. Again, background, Washington County has asked all the municipalities to adopt an ordinance requiring a county treasurer signature block on final plats. This is due to subdividing of parent parcels which owe back taxes, even though the new parcels with new tax numbers stay current on their property taxes. The owners, says here, are losing their homes because the parent parcel's taxes are years past due. The Washington County Attorney prepared this draft ordinance. See the attorney's findings below. Our town attorney, Heath Snow, has reviewed it, and he has recommended you put it in the findings. He said, although he might suggest a different word here or there, he thought that in an effort to keep consistency, that the town should pass it as is. That's drafted by the county attorney. And then it says, accordingly, see if you can obtain the ordinance in modifiable format and insert the town of Leeds where it says municipality throughout, and add a signature block for the mayor and the attestation block. With that, it should be ready to go to the council. If you had a chance to look at your agenda packet, there is an ordinance. It's ordinance 2012-04. There's the first page of the whole series of whereas, and it's the resolution and all that. But the wording is basically the same as the findings. So let me just quickly review the findings for saving time on this. The purpose, again, is this. The purpose of the provision, the purpose of this ordinance is to require that the county treasurer sign final plats prior to their approval in order to certify that taxes, special assessments, and fees due and owing on the property have been paid in full. Okay, so the findings, as prepared by the attorney, is A, there have been instances in Washington County where a land developer has failed to pay a delinquent tax on the property and then subdivided the property and sold it, in which case then that problem gets passed on to the new buyer. So that's not a good situation. When this occurs within a few years of purchasing the property, the new owner learns of the delinquent tax, and unless something can be arranged with the developer, the new owner is responsible to pay the delinquent tax. And C, this unfortunate situation can be prevented by having the county treasurer certify that no taxes are owing prior to final plat approval and recording it. D, Leeds is working with Washington County and other municipalities within the county to pass a similar amendment to their final plat ordinances. Having a uniform requirement throughout Washington County will prevent confusion on the part of developers and promote the payment of taxes prior to the final plat approval. And E, requiring the county treasurer sign in the signature block area of the final plat will make it clear that no taxes are owed on the property. And F, Utah Code annotated the citation that says authorized municipalities and counties respectively to withhold the approval of the final plat until a tax clearance is provided. So, and those are, it goes on, there's a few others, that's the basis of it. The ordinance is pretty simple. The actual wording, it says the following amendment of ordinance 2012-01, adding sections 21.8.211 and changing subsection 21.8.2.11. to be 21.8.2.12 of the Leeds Code and hereby adopted language. So this, the new language is underlined, and this is the new language. The item 11, this is again in the subdivision ordinance, says the signature of the county treasurer indicating at the time of the signing that the property taxes, special assessments, and fees dues and owing have been paid in full. So a little background, I just clipped out, St. George City is going through this very same process. This, I'm going to pass it around, this is a little signature block, and you've seen a final plat at the bottom. There's a series of the mayor signed, chairman of the planning commission, the county attorney. So there's the treasurer's approval. If you want to just look at, there's the, just clip that out of it. So that is the request, and it is an amendment to the subdivision ordinance, so it does require a public hearing, and then you will make a recommendation to the town council. I don't know if you have any questions of me. I think it's pretty straightforward.
I just want to add to it, the reason this is coming about is because a couple of subdivisions in the county were approved, and the municipality or the county in which they were located did not do a full title report check. And so the parent parcel, which would be the parcel before it was subdivided, did not have all its property taxes paid in full. Then they subdivided the parcel, and the new owners began paying property taxes on the subdivided parcel, but because the parent parcel wasn't, didn't have the property taxes paid on, because something in their checklist was off, people ended up losing their homes. And so, this is the county's way of trying to deal with it and make sure that unfortunate situation doesn't happen again. Our current checklist requires that title report, and so it's never been an issue here in Leeds. My concern with this was the unintended consequences that might happen, and that the county could come up with some new fee or something without an interlocal agreement or without Leeds. And then there might be an unintended consequences for years down the road, this signature block could be abused. I talked to Heath Snow about that. He alleviated those concerns by helping me understand that if the county were to ever abuse the signature block, we could just simply revoke the ordinance. So my concerns were alleviated, and I thought it was helpful to understand why they were asking for an additional layer of government. I don't think an additional layer of government is usually a good idea. But anyway, that's just something I found out I wanted to pass on, where I had that legal question asked Mr. Snow. Is there any other? Bob, did you have something?
Well, I think, it hasn't been a problem actually in St. George City either, and probably not in most cities, because, if you require title reports, I think you would catch it. That's not a totally fail-safe system either.
Somebody could make a mistake.
Yeah, and, but when you're taking it down to the county to get it recorded, hopefully that, you go to the county recorder, that should be just one step before that. The county treasurer does a quick check, passes it on the recorder, and get it recorded. Hopefully it won't be a real burden, but it will say, it will prevent the problem. When it does occur, it's pretty painful for those who get caught in that situation.
Sure. And I think it happened twice in the county. Any other questions on Commissioner?
I have one where it says whereas the Leeds Planning Commission has held a public hearing and unanimously recommended changes to clarify this ordinance. Did we have a public hearing?
That's tonight. I think there's
That's what we're doing tonight.
yeah, the public hearing will be tonight, and then you have to vote. So this is just obviously a draft, and then an ordinance draft.
Looking very positive this one. Okay, if there's no other discussion, let's move to item number 8. We need a motion to open the public hearing.
I'll make a motion to open the public hearing on Dr. 12-04.
Thank you. Okay, with the public hearing, a few rules on public hearings is we're interested in hearing your comments, particularly if you've heard anything that our staff report did not discuss or we haven't discussed. We want to make sure that we make good decisions and that we have input from the public in order to make those good decisions. If you have a comment that's already been discussed, please hold it. We will make notes. We will take the comments. Our time's valuable. Your time's valuable. I will interrupt you if you're repeating comments that have already been discussed. And so keep it brief, 3 minutes or less. And if anybody has any comments about this, please come to the microphone, let us know who you are. And
So is this just pertaining to this ordinance you just talked about? or
only this ordinance.
Looking at your agenda, Anita Lowe, looking at your agenda under public hearing, I do not see that the county treasury block is an item on your public hearing. So it is not as a public hearing item for tonight, and you can't have any action on it.
It's item number 7 and 8.
7 and 8 says subdivision.
Well, that's what it is. It's that changing subdivision ordinance to add
It's
the
not a
signature.
separate ordinance on its own.
No, it's an amendment to the subdivision ordinance to require a signature block.
Well, it just doesn't state that in your public hearing at all.
It's an amendment to the subdivision code.
Or I'm just stating the fact that it doesn't say that. So that was my concern.
Thank you. Any other public comments?
Hi, Danielle Sturman. Is there an added cost for the town to be able to have this other ordinance? Is the county going to charge for each one that they actually look up or sign?
Signature blocks, I'm not aware of there ever being a cost on a signature block.
They haven't, there's been no indication of a fee on this.
Is there a way that we can make sure that that's kind of looked into before the town has to come up with more money, maybe for something that the individual could be able to pay for instead of passing it on? If that makes sense at all. I kind of like to know a price before you actually sign the dotted line.
It wouldn't be a fee assessed to the town.
Right.
If the county decided that having the treasurer, there was a fee involved, that would be something that the developer, whoever's recording the plat would be responsible for. You know, to my knowledge, there's been no indication the county plans to charge a fee on it.
I think it'd just be advantageous to be able to see that, because for one thing, I think that we have the availability, if you're buying something, you have the availability of going ahead and doing your own check, which is a good thing that the county wants to be proactive in that. But if there is going to be a fee, it would be, I would like to know what that is. Thank you.
So Danielle, your concern is to make sure there's no extra fees as it relates to reporting of the plat.
Right.
Thank you.
Alan Roberts, I'm going to speak as the mayor in response to Danielle's question because I've had full dialogue with the county commissioners and how this ordinance that's been asked by the municipalities came about. Jared explained how it came about. Unfortunately, title insurance should take care of this. It does not. And it has not in a number of cases because you have some title companies that no longer exist. So how do you go after them for some inappropriate actions that they've done or a failure to follow through with what they've done? So the county is asking, there is no fee. The county does not charge fee for signature on final plats. They never have. There's no reason for them to in the future.
Thank you, Mayor. I'm not aware of a single city or town in the state that charges for signing a signature block. Okay, are there any more public comment? I move to close the public hearing. All in favor?
Aye.
I,
Okay, item number 9, action item, discussion and possible recommendation on county signature block on final plats. Was that a motion to make a recommendation for we do have some good wording on our staff report. If somebody was comfortable with that wording for a motion.
Want a motion on number 11?
Number 9.
Yeah, that's the word.
So I'll make a motion that we send the stipulation of the signature of the county treasurer indicating the time of signing of property taxes, special assessments, and fees due and owing have been paid in full, and send this to the town council for review.
For approval, or you recommend approval?
I'm recommending approval.
Do we have a second? Second. All in favor?
Aye.
I,
Aye. Okay, discussion, we'll move to discussion items on the agenda. Item number 10, discussion on possible amendment to the sign ordinance. Mr. Nicholson?
Okay, we started this discussion at the last meeting, and I think there was some good input. So I've gone back and made a few changes. Let me just highlight it, again, just for discussion. So let me kind of just, maybe go to the changes. Sign ordinances, because they have a lot of legal aspects to it, are fairly lengthy by nature. It's a little bit of an aggravation to realize that you have to wade through 25 pages for a small town sign ordinance, but there's a lot of, legalistic aspects to it. But anyway, let me just, in general, like Leeds has a good sign ordinance, and the changes that I suggested are relatively minor, and the main ones, I guess, would deal with the commercial signs. We talked last time about political and campaign signs, but we need to eliminate most of the regulations that are currently in place simply because they're not legal. And our town attorney say the same thing, that political signs, campaign signs are kind of a protected category. And I've seen cases where, you try and regulate much in the way of political speech, political or campaign signage, it's denied by the court. So let me just talk about the signs, the commercial signs primarily. I've suggested that they delete this language about the master sign program for a business center. To me, it seems rather confusing. Page 22-4. 22-4, it says signs requiring approval. So 22-4, most of that sections are stricken. And then going on to page 22-5, you can see it says business center sign. So that discussion on those signs is replaced with basically 3 sections. And one is the wall signs, which Leeds already allows, but I'll be just simplified. It says wall signs in commercial zones. Each commercial building or tenant therein may have one wall sign not to exceed 10% of the building's front wall area or 10% of the tenant's front facade area. Such wall sign shall be attached flat against the building's wall and shall not extend above the roof peak or parapet wall. On side or rear wall of the building, not more than 5% of the wall area shall be used for one additional sign. So, pretty straightforward, I think, on a sign attached to a building. Then, on a business monument sign, I have not really suggested maybe a minor change on the monument sign. I think the way it's drafted, unless the planning commission or town council has problems with the monument sign, I think it seems to work. So let me just read that. I noted that this is current section 22.2.2.1. It says monument signs shall be mounted on the ground with a solid base. The size of the base shall be no larger than 30 square feet and a height not to exceed 2 feet. Well, you know, if it's 2 feet, that means 15 feet long. So roughly, but that's not that's not an unreasonable size for a base. It's only 2 feet high, and the sign portion of the monument shall not exceed 55 square feet, with the top of the sign no more than 10 feet above the highest ground elevation adjacent to the sign. The sign shall be within the property for which it advertises and shall not encroach into any public right-of-way or public property. So that's, I think, existing language that for commercial property with more than 100 feet of frontage on public street, the size of the sign may be increased at a rate of 1 additional square foot of sign area for every 2 feet of public street frontage in excess of 100 feet up to a maximum sign area of 120 square feet. So, that sign, if they had more than 100 feet of frontage on a public street. So that would max out at 120 square feet. So it's 10 feet is maximum height, so that means it could be a 10 by 12, 10 feet tall, 12 feet wide. If you have questions, sometimes a satellite fixed sign actually, when you're driving down the highway, is finding how it doesn't appear to be. And I could actually bring examples around St. George of what 120 square foot sign would be.
So you're limiting those quite a bit, like 500 feet from the freeways,
Not on the monument signs.
but on the whole sign.
Okay, let's go on to the next section. So that talks about monument signs. Monument signs again are by nature low profile, 10 feet tall. Then we've added this section. This is this was a result of discussion. I think Jared mentioned like the storage center, the storage units there on the south freeway exit. So this is a proposal. One pole sign up to 30 feet high as measured from adjacent ground level is permitted for a commercial property of 1 acre or larger and located within 500 feet of the freeway exit as measured from the center point of the freeway cross street. The pole sign shall not exceed 150 square feet in sign area measured on one face. And the pole sign shall be separated by at least 100 feet from any other commercial pole sign. So right now, in the Leeds code, there is no allowance for a pole sign. And there's nothing magic about these numbers or this height or anything, this height. These are some that I'm somewhat familiar with from other towns. One thing I think to consider is the freeway, from a commercial standpoint, is really the lifeblood of the commercial venture. Whenever you have a freeway interchange, and then the possibility to have some kind of commercial services that services particularly I-15 traffic. There's convenience store, gas stations, whatever. But if people come down the freeway can't see, the business or know that they're there, then business will never succeed. So if you're going to have a freeway-oriented business succeed, you're going to have to be able to get the message out to the public, which is going to basically mandate some kind of a pole sign. 30 feet is not very tall. You may say it's not tall enough, and I certainly accept that. So that's a new provision. And then there's let's see. The sign is not exceed 150 square feet in sign area. Again, that's a rather medium sized, and if you'd like next time, in fact, I could bring examples of a pole sign that's 150 square feet side in an area. If you want it.
Might be helpful.
So that's kind of to address your issue, that not only the storage units, but any potential future commercial development that may happen at one of your freeway exits. The only way they're going to be successful, really, is be able to get the word out to the people up and down going up and down I-15.
Well, we did the sign ordinance so that we wouldn't have to have a bunch of banners everywhere. And then our sign ordinance limited the size so bad that the business couldn't get their message out because nobody could read their phone number on a small sign. So then we ended up with a bunch of banners. So we gotta strike that balance of keeping things attractive, but actually giving a business something that's functional. And is your feeling 30 feet is tall enough to give them something functional? I mean, are we mitigating it? Because it's been a house is that tall.
You know, I don't know what the right number is. In St. George, we allow 50-foot tall sign in proximity to the interchange. Now, Leeds has got a more restrictive sign code, but I don't want to necessarily tinker with it. I think in general, it's a pretty nice sign code. Now, 30 feet would be the minimum. 50 feet, you know, it's probably, you may not need to go 50 feet.
30 feet would be a minimum or a maximum?
A minimum, I think. You know, you're, as far as attracting and getting the message out to freeway traffic, if you're not 30 feet, then it's probably not going to be visible.
You mean a minimum for advertising?
A minimum, yeah, a minimum height. I don't think you can't go a 20-foot pole sign and expect the freeway traffic to pick that up.
So you're saying the lowest it could possibly be is 30 feet?
I think to be effective.
Okay.
Now, you may, like say, you know, St. George, I don't want to necessarily suggest 50 feet, but I'll just say that's what St. George allows. In proximity to an interchange only. In town, 30 feet is the max, or if you're not in proximity to an interchange. So 30 feet is the St. George standard for pole sign.
Do you have a maximum in mind?
For a pole sign?
I think he's suggesting what he would think is minimum and what he put in here is our maximum.
Yeah, I think, you know, 30 to feet to 40 in that range. Is probably what is going to be effective. If the idea behind it is to get the word out to people that are traveling I-15. And I-15 is the lifeblood of a lot of commercial. I mean, you know, you got commercial development, which I'm sure brings some benefits. You know, they pay sales tax and provide some services that Leeds residents to enjoy. So anyway, they're just suggestions, and I don't know if you know, I can bring back some photos, both the sign size and the area. You know, you may have a hard time in visualizing what's a 120 square foot sign per monument, what's a 150-foot sign on a pole sign. I could bring you some examples, and you could might help you visualize it.
I think that'd be helpful because I think we want to pass those through as their staff report to the town council. That's part of what we're vetting. How's the rest of the commission?
Yeah, I agree.
I don't know what other comments, do you feel, right now, there are no pole signs allowed in Leeds, and you know, there's kind of a charming thing in a way, but.
I don't know how you not do it, man, gas station.
Yeah,
I think you don't have a post on that.
I don't know how they're gonna be able to catch at least the freeway traffic.
What other items did you want to get tonight, or does everything else remain the same?
Well, I can just glance through here. Those are the main changes, really. The most significant ones are the deal with the commercial business signs, commercial zones.
Looks like all the other changes we've discussed before.
Yeah, the rest, you know, they're pretty minor. Sometimes I kind of residential zones go from a 2 square foot to a 4 square foot sign. Simply because the 2 square foot is like a 1 foot by 2 foot. I mean, those are historic flat almost.
Are we changing the civic sign measurement? Like the Leeds entrance sign?
No.
It's in here, it says 24 square feet, but I think Ray said that.
Yeah, and in the latest draft, we changed that. We changed that to 72.
It is changed then?
Yeah, for civic signs, for the, and that's on page 22-2. Yeah, I went from 24 to 72.
This wasn't on this.
Well, let's see, there's.
I have another one, historical section,
The historical sign? The historical sign? That is correct. Bob, it sounds like we're looking for pictures on our next meeting, and make sure we get our historical signs and the ordinance conforming with what we did,
Okay,
kind of backward.
you have some information on the historic sign? Okay, you can maybe get it to me or something, or you can call it, I'll make you know.
Bob, excuse me, it looks like the prohibited signs is all stayed the same in this ordinance. So,
Yes.
It all makes sense.
So the general, I think it's a good sign ordinance. Again, it's fairly restrictive, which probably the citizenry supports. The signs are generally small, which is good. I mean, so in general, I haven't recommended very many changes. Other than those commercial signs.
Thank you for your work. Unless there's any other discussion, is there any other discussion? Okay, let's move on to item number 11. Boss, if you mind, go ahead and present that.
Okay. Item number 11, discussion on annexations, disconnects or de-annexations, development agreements, interlocal agreements, franchise agreements, and special service districts and basic local districts. I think the purpose of this is just for information, education for the planning commission, and maybe anybody in attendance. So, let's see, make sure we get it on here. I'm going to read it. I didn't prepare this deck before, but I think it's well done. It says, many of the following items are tools in the state code for local governments to coordinate services and keep liability and the payment for services for those who are benefiting from the service. An understanding of how these work helps us as a planning and zoning commission in the town deal with questions and applications. For instance, Hidden Valley is a part of the community but not part of Leeds town boundaries. Some residents of that area have asked how they could be annexed but are very concerned about protecting their water, among other things, that is owned and operated by a county-created special service district. We are not here tonight to talk about annexing this part of the county. This is, however, a good case study to talk about different tools local governments can use to serve the public interest when questions and coordination needs arise. The concern of how a basic local district, which is like a special service district is used, has come up in discussions, with many misunderstandings being repeated around town. The purpose tonight is to discuss these items and how they can be used or have been used in town and within our annexation area, given a number of concerns that are about. So, again, this is kind of an information, educational overview of some of these things that are in the state code. Number one is the annexations, which is a method to incorporate territory into an existing political unit, such as state, county, or city. If somebody wants to become a part of Leeds, they submit a petition to the city, goes to the city clerk. The state code, there's a bunch of there's probably 20 pages that deal with annexations in the Utah code and how they have to be treated. Basically, it's about a 60-day process. You have to accept the petition. It has to meet the standards of the state law, which means that the property owner, there has to be a majority of property owners in favor of annexing. Those owners have to represent, I think it is at least 33% of the assessed value, I think it is in the state code. And that's the minimum threshold it has to meet in order to be considered. Now, that doesn't guarantee that the town has to accept it.
Where do you find that?
That's in the Utah code.
What is that?
Well, Utah code is the state legislature, it's the state laws of Utah. And it will be in all the, it's, let's see, title, I know it's Title 10, if you go into Utah code. If you go to Google and if you go into Google and you put Utah annexation law, it'll come back as Title 10, section something, I don't know. Anyway, I'm a little familiar with it because one of my functions with St. George's processing annexation. Anyway, unless you have questions, maybe we move on. Disconnect is if people want to be disconnected from a town or a special service district, then they can file a petition that kind of works the same way. There's a process to be disconnected from a town, or de-annexed is also the term used. And it happens. There's also a thing that's probably more frequently called municipal boundary adjustments. Two towns can work together and adjust their common boundaries. St. George has done that a number of times. Santa Clara was also done with the city of Washington, so just working out, things that would make most sense. So, should we go on to the next one?
Well, let's stop for a minute. As far as commissioners, do we want to discuss these items when they come up, go through all of them, and then come back and discuss them? And it probably works if we're doing it both ways. In one way, if we go through all of them, then we can discuss how they work together when we actually start discussing. Or we could bring up different discussion points as we go through. So, if anybody have strong feelings either way. Well, let's go ahead and just go through all of them, and then we'll come back.
Yeah, and if there's questions on any of these, I guess this is what it's all about, is just having a discussion, so get questions good. The next one is the development agreement, which is a contract between a local jurisdiction and a person who has ownership or control of property. Usually it's a developer of property. The purpose of the agreement is to specify the standards and conditions that will govern development of the property. The development agreement provides assurance to the developer that he/she may proceed to develop the property subject to the rules and regulations in effect at the time of approval. The developer will not be subject to subsequent changes in regulations. And then the development agreement should also benefit the local jurisdiction. The city or county may include conditions or mitigation measures that must be met to assure that a project at a site-specific location does not have unacceptable impacts on neighboring properties or community infrastructure. The agreement may clarify how the project will be phased, the required timing of public improvements, the developer's contribution toward funding system-wide community improvements, and other conditions. The agreement can also facilitate enforcement of requirements since it is a contract that details the obligations of the developer and the local jurisdiction. In Washington, I think that's supposed to be in Washington County, the project is subject to the regulations in effect at the time of the subdivision or building permit application. However, the development agreement may include additional development standards that will govern property development for the duration of the agreement. That goes all over. agreement between the developer and the town, both sets forth obligations of each party. You know, usually, most of them I've seen deal with the timing of public improvements. If you've got a large subdivision, you say this road has to be built at a certain time, this has to be done, and all the different public improvements come into play. So that's, and then the developer often, if you will, as it's stated here, will want some protection from future, major changes to get the regulations effective in the development.
Okay.
Go on. Interlocal agreements is simply a contract or agreement between government agencies that work to provide services to the public, such as parks and bus systems. An interlocal agreement can exist between cities and schools, or counties and school districts. Can, typically between two cities or multiple cities. These agreements permit government agencies in an area to share their budgets to reach a common goal they may be unable to reach separately. There's, between the cities in Washington County, there's a lot of interlocal agreements, and they talk about things such as the dispatch center and how it's going to be paid for, and also that there's this fairly common tool between government entities. Franchise agreements is a contract between a municipality and a private utility company, very similar to an interlocal agreement. They usually define the service area processes and terms and conditions to which the municipality and private company work together for the public interest. So those franchise agreements usually on the natural gas, phone service, whatever, telephone.
Here it would be appropriate to have one with our two private water companies.
Yeah, and I know it's majority of the franchise agreement for the cable TV providers. And it sets forth the rules and regulations and, how to use the public right of ways and, special service districts. Special service districts, the defined area within the city where special services are rendered, and the costs of the special services are paid from the revenues collected from service charges imposed within that area. An SSD, or a special service district, may be established anywhere in the city, but only business property by commercial, industrial, utility, or land zone commercial or industrial use will be subject to the service charge. SSDs are commonly used in areas with a concentration of retail stores. One way for a city to provide an increased level of service or infrastructure to its service districts, to its commercial or industrial areas to create a special service district. Special service districts are established at the request of the persons who will pay for the increased level of service. And that's obviously the key, property owners come together, petition the town, provide the service, and they're willing to pay for it.
Well, let me just point out an inaccuracy there. I think there's some omitted that SSD can cover even residential land, park land. It can cover any land.
Yeah,
It just depends on the service that special service district is providing. But the rest of the point in here is accurate.
I'm glad you thought, because that was my understanding as well, and I'm not sure if now they call those special assessment areas.
Which we get into in the next agenda item. I think this kind of crossed over. That one sentence is out of place. But it is a way for a municipality to localize a needed improvement to a specific area and make sure that only those people pay for it.
So that pretty well, then there's the next one is the basic local districts. This is, I think, a relatively new provision in the Utah law, that it allows a special service district can have up to 4 services. They can establish a district in a particular area of town and provide 4 municipal type services, say parks and recreation, sewer, I forget what all there, maybe street maintenance, wheelers, they can identify 4 services that an area that she wants to have. The difference between a special, and I guess in the next session, on special assessment areas is, and they used to be called special improvement districts. St. George has probably a dozen, had a number of them over time. And cities throughout the county have what used to be called special improvement districts, they now call them special assessment areas. Property owners come together, they petition the town to create a district.
Bob, I don't want to be rude, but that's in item number 12.
Okay.
So let's just say that for item 12. Well, I think these definitions are great. It's awful boring to sit around and read definitions. Mrs. Burton, this kind of got put on the agenda because of you were asking questions about, hey, if Hidden Valley wanted to get annexed, what would be the different tools to protect us in our different concerns and how would we do it. In general, an annexation petition, in order to be accepted, has to have 33% of the property value sign up on the plat. And in Leeds, we have an interesting tradition, and you can see it by how odd-looking our town boundaries are. For instance, when Grapevine Wash came into the annex, they wanted to just follow the law and take a big group of people in, and they had enough taxable value to do it. Mr. Howard was here. He asked that he not be pulled into their annexation. I believe the News asked the same, and several other property owners. So Grapevine being, they acquiesced to that request, split their annexation into 2 different plats. And they annexed one petition in and then later annexed another for that and other reasons. There was a 3rd annexation petition because we were going through a boundary line dispute with Tokerville. And they, even though it was an additional cost to them and virtually no benefit to them, they waited and did the 3rd annexation petition. Interestingly enough, there's some property that Mr. Hamilton now owns that as a property owner, I've done the annexation petition on that flight. And both times decided not to go forward and bring it into the town. But that was a single person annexation where no other property owners were involved. And so that was really easy. You asked the question about what about your water and how that works with your special service district that provides water.
We have Angel Springs Special Service
Yeah, and so
with the county.
So that's why the interlocal agreements here and the definition of that, because during an annexation process, an interlocal agreement could be negotiated to meet the concerns of that special service district. And so it's still, it's just an agreement that could spell that out.
But we would still be separate. I mean, they couldn't touch us.
Yeah, that special service district
Right.
could definitely remain intact. An interlocal agreement would help negotiate the different deal points that would be important to that special service district and different deal points that would be important to the town. And if the agreement could be made, then that could be part of the annexation agreement. So that could resolve, I mean, if there's issues there that can be overcome, that agreement would be what would govern those concerns. The issue of how you pay for roads and other things we can discuss on item number 12.
I just going to, since you're talking about annexation, there's one other thing that we ought to mention is that now under the Utah law, and it's been this way for at least the last 10, maybe 15 years, they require towns to adopt what they call a future growth area, a master annexation area that identifies, and obviously those can be amended from time to time, but it requires towns to set forth what they feel is their future potential boundary. And then when an annexation comes in, it has to be within, and that's, well, excuse me, that master annexation area has to be approved by the county council. And it just sets forth our future boundary. Now, you get towns that may have overlapping boundaries, which is not uncommon. I mean, Tocqueville and Leeds may claim the same future area. It just says, this is an area we will consider annexation in. So when the petition comes forward, step one is it has to be within this so-called future growth area. If it isn't, then that town doesn't proceed. And it's, unless they go back and amend their master annexation area. Now, in a case where two towns say, well, we're willing to accept this same property, then the property owner kind of has a choice. You've got two towns that are willing to take the property, and then it's up to him to petition one or the other. And in the case, then there's what they call the county boundary commission. So if there turns out to be an annexation dispute, it goes to the county boundary commission for resolution. So anyway, that's just a little insight on some of the other provisions of the Utah code.
Now, to get a petition accepted for review by the town, it's only 33% of the property value. But to actually fully affect a petition, it would need to be approved by a much higher percentage. There is a higher threshold at the end of the process that more than, I know it's more than half of the property value has to agree to the annexation petition. And so that's by law. Leeds history, and you can see it with its jagged edges, is we typically don't want to force anybody in. We would like people to petition and willfully want to be part of the town. And so in a hidden valley area, it's a little different than any annexation that I'm aware of that Leeds has done. Well, I don't know, it'd be very similar to El Dorado Hills and Silver. Those areas are annexed.
But
With
even
already
if we
having
meet
been
the
developed.
criteria, doesn't mean these laws. Oh, okay.
Yeah. Leeds still has a choice. Yeah. So, and I'm sure there's concerns both ways with how that would come together, and that's why quite often there's annexation agreements to deal with those concerns. I know there would be zoning issues and legal non-conforming uses. What zone would be your base zone, and what would you get pulled in under, and all those things are typically worked out in that period of time between when the petition is filed and when it's actually, when the ordinance is actually accepted. And so it's quite a process, and it's pretty well detailed so that anybody involved in the process has plenty of time to get involved.
And again, it's spelled out in the Utah code. I mean, they have a complete section on annexation, and we think it's a difficult read because they talk about first-class county, which is primarily Salt Lake County, and then everybody else, and
Wherever
there's a lot of process steps that you have to go through.
So on disconnects, I've actually been involved in a disconnect. And a disconnect basically happens when a city or municipality, it usually happens when a city or municipality is unable to provide services to a property owner. And so a property owner can go request a disconnect, go back to an unincorporated county, and then search out a way that their property can be provided services. Disconnects, I think the most famous disconnect in Utah is the Bluffdale case, where that government decided to misuse their government power, and a third of their city was lost. And it was based off of their arbitrary and capricious attempt to require more like HOA type rules versus health, safety, and welfare. And so disconnects can happen. One of the reasons I ran for city council is I was nervous that Leeds wouldn't be a city and we wouldn't be able to govern stuff because we had no agreements to provide sewer, and we didn't have any way to provide meaningful water. And so I was quite concerned when I ran for town council that if Leeds didn't get into gear and get to where they could provide water service and sewer service, at least have agreements in place, that we could have property owners start petitioning to disconnect out of the town. And if we weren't ready and willing and able to at least allow them to pay for the system improvements they would need, there would be no basis to hold them in the town. Development agreements, I think that definition was pretty well explanatory. Is there any discussion from any commissioners on it, or maybe even back to disconnect?
Apparently a disconnect is not the same thing as the annexation.
Yeah.
It is.
It is.
So is that what's happening over in Apple Valley? Is that the same thing that's happening over Apple Valley?
No, that is a disincorporation, I think. Now, maybe you may have both around, but what Apple Valley is trying to do is do away with the town. And that is a disincorporation, and I'm not sure about what the process is, the voter process, but I don't know much about it.
De-annexation is actually not a legal term, so disconnect is the legal term for de-annexation.
That's the same thing.
It is, it's the same thing.
Interlocal agreement, example of that for us to wrap our heads around is we have the fire special service district here. And we have some stuff between our code and them that we constantly coordinate. And it may be beneficial to figure out how to do an interlocal agreement with the fire special service district. We have impact fees that we collect, spell out how those go back and forth. I know the towns, the fire chiefs petitioned the town before to, I'm trying to remember the exact issue. He needed guidance and direction on if in the wildland interface zone, if somebody did not comply with the code, or if fire approaches that house, if we wanted him to order federal funds to put that fire out. And so he asked for guidance and direction on that. We gave that to him, but it might be a more appropriate place to put all those things in one interlocal agreement, so there's council's change, there's fire chief change, there's a governing document instead of institutional memory for digging through old ordinances. And then also, this is Burton, your deal with this special service district, obviously, would fit in there. Franchise agreement, franchise agreements, like it would be perfectly appropriate to have a franchise agreement with LEWA or Leeds Water Company. And some examples of why that could be important is the town approved the Boulder Way subdivision because they got a letter from every utility company stating that there was water on all those lots. And then, because the town is not into allowing subdivision approvals for dry lots. And then later, LDWA and the developer agreed to not provide water to one of the lots without incorporating the town in the loop. And so that's created some problems in town. And that's a good example of why you would want a franchise agreement to give guidance and direction that if we approve a subdivision and you provide a letter stating that every lot has water, you have to follow through and be sure every lot has water. So that's an example where some friction has happened. I know Leeds Water Company ran into problems when they put in their irrigation line because they were not on the signature block of plats. And the Sitla property had a plat come through, and there's a prescriptive easement for the Leeds Water Company water line. And people who bought in that subdivision and others tried to claim that because there's a plat recorded that easement no longer existed. And so a franchise agreement could include stuff that makes sure that Leeds Water Company would be able to check off on plats and make sure their easements are noted on the plat. It would resolve a lot of issues to be able to have those agreements because it would outline a process to how we work together. Special service districts, I think we covered those. The basic local district is basically like a special service district. It's kind of new. They have the 4 services. A basic local district like a special service district can can own and operate the facilities they construct, or they can just construct those facilities and turn them over to the local municipality. They're basically used so that you can localize costs to those who are getting the services. In the instance of the basic local district we have here in town, in the annexation agreement with Grapevine, the town required that they do an interlocal agreement that is acceptable to the town, so that we wouldn't have another entity that was just running around road like we have in Leeds all the time. And that there would be function and how those entities work together. And so that interlocal agreement will basically let that basic local district localize the cost, bear the financial burden, but do it in a way that's acceptable to the town. And where the town has still obviously a local district and an SSD is not a land use authority. They can only have authority over their different services. But the interlocal agreement with Grapevine can spell out and dictate those terms and how that district can operate, whether they maintain a facility or not, can ultimately be the decision of the town through that interlocal agreement. Is there any other discussion items or questions on those? Okay. Let's move on to item number 12. Item number 12 is discussion on impact fees, capital facilities plans, reimbursement agreements, general obligation bonds, special obligation bonds, state infrastructure loans, special assessment areas or SAAs, formerly known as special improvement districts, grants, BNC road funds, property tax, franchise tax, and sales tax. Bob, you mind leading out on this one as well?
Okay. I think this is the same purpose that was put on the agenda, just for educational information for the Plan Commission and the public. So I didn't prepare the report. I think it's well done, so I'll go through it. It says, in several public hearings over the last few months, the concerns of roads needing repair, and in some cases redone, have come up. El Dorado Hills being a specific example among others that are being asked about. Also, some have expressed concern for how LDWA has allocated repayment of the loan for the recent improvement project and how impact fees are assessed in that company as well as in the town in general and in the Grapevine Wash area. While with LDWA, it is an issue and for the shareholders to address with those running the company, the understanding of how the following items work will be helpful in addressing these among other concerns. In general, the need exists for understanding how funding mechanisms work and the guiding principles for the traditional ways of general and specific obligation bonds, as well as the more common approach as of late being state or federal grants and or loans. An understanding of how our Utah laws govern impact fees is needed to clear up a bunch of confusion in town. First of all, impact fees. Impact fees means the payment of money imposed upon new development activity as a condition of development approval to mitigate the impact of the new development on public infrastructure. The impact fee does not mean a tax, a special assessment, a building permit fee, and a hookup fee, a fee for project improvements or other reasonable permit or application fees. So, impact fees are assessment on, like it says, on new development to cover the costs of the town for building basic infrastructure. So typical impact fee could be for water, sewer, streets, parks. Different cities will impose different types of fees. And actually, that's also covered in depth in the Utah Code. And because the law changed here just recently, the legislature, it's actually in Title, it's Title 11, Section 36A. So there's another 15 pages of small print on how a town has to collect and
Does that,
stand impact fees.
does that govern just town?
In all counties can also charge them, and I think special service districts, but it talks about, and the analysis that's required in order to impose them. You can't use impact fees to make up deficiencies in, existing conditions within a town. And you can only use them to meet the same level of service that the town has in general. I mean, again, you don't use impact fees to make up deficiencies for how you'd like things to be. So there's.
It also governs private companies as well.
Yeah, it's, anyway, I don't know how much you definitely want to go into that, but I know Leeds does charge a street impact fee, a park impact fee. I believe there's a public safety fee, and that's assessed at the time somebody obtains a building permit.
And those impact fees have to have a direct correlation to costs. They
Yeah,
cannot be arbitrary.
Right, you have a fee, you have to keep a special account for sewer fees, park fees, street fees. They can't be intermingled, and you have to use them within 6 years for impacts related to new development. So that's an extremely brief summation of the impact fees. There's a lot of regulations about going to the collection and how you justify the charging impact fees. Should we go on?
Yes.
Capital facility plan, the infrastructure plans that define system improvements, project cost, and projected time. And these plans are usually the basis to which impact fees are based on. And that's absolutely correct. The first step in an impact fee analysis is for a town to develop a capital facility plan. Last year they changed the name of that to an impact fee facilities plan, but it's basically, so you have to look and determine, what road improvements do you anticipate in the company over the next 6 to 10 years. Same thing with water systems, parks, and then based on that facility plan, you can assess the impact fee. So, reimbursement agreements, so usually when a property owner funds system improvements beyond their needs or in place of local government. Repayment is typically only as building permits are issued or others hook on to the system within a certain period of time. One form of reimbursement could be to offer impact fee credits. Old Babylon Mill Road water line was constructed with a reimbursement agreement in place between the developer landowner and the LPWA.
Does that sound really stupid? What does LPWA stand for?
Leeds Domestic Water Users Association.
What is it?
Leeds Domestic Water Users Association.
Do we want to have any discussion on reimbursement agreements? They're
Pretty simple.
pretty simple, straightforward. General obligation bonds, is something that has to be approved by the general the citizenry, the voters. Voters have to approve the general obligation bond, whether it's with the district, the town, whatever. So it means a bond that is directly payable for unsecured by ad valorem property taxes that are levied. So the majority of the public has to be in favor of a general obligation bond, and it becomes in an assessment on the property tax.
You can skip the special.
Special obligation bonds, they're like general obligation bonds, only for special areas. Again, I think they require voter approval. I'm not very familiar with the special obligation bonds.
So the difference is say, you have a system-wide improvement, you could pass a general obligation bond that benefits everybody. But if you have, say, one area of town, let's say Vista Avenue, that road is in pretty bad shape. It doesn't really serve Silver Reef it doesn't serve the main part of town, it would not be acceptable to be a general obligation bond and burden somebody in Silver Reef with the improvements of Vista Avenue. So the city could do a special obligation bond and localize the bond to only those who benefit from it, and those in that area would vote just like as in a general obligation bond, but just in that specialized area. It's kind of like they use an SAA to make it work now. So, but the principle behind those two has kind of gotten lost with how our government now goes to Washington D.C. and asks for block grants back to the states and then asks for state infrastructure loans. Because the neat thing about a general obligation bond and a special obligation bond or an SAA, or even how a basic local district operates, is that those who are affected have the opportunity to check the power of the board that researches the project, gets a capital facility project done, and says this is what we think we need, this is the cost, and this is why we want to do it. With a general obligation bond or a special obligation bond or an SAA, the public has the opportunity to say, we agree with our elected official or we don't. And if they don't, they go back to the drawing board and figure out another way to deal with the problem. If they agree, they pass the bond, and it's a very efficient way to provide a service because there's not the loss of 50% of the revenue when it goes to the federal government before it comes to the state in a block grant, and there's not restraints attached and a loss of 30% of the revenue when it comes to the state, and there's also not the people then paying back the very money which they funded, which they only got to use 20% of. And so a special, it's kind of an old school way we used to do things before the 16th Amendment was passed. We still do it on occasions. Cities do special assessment areas all the time. It's just a very efficient way to provide services.
But you have to convince the public that it's a worthwhile project or they're not going to vote for it.
Yep. It really makes those capital facilities plan tight, really well thought out, because there's that extra check on power by those who are paying the bill.
The next item is the state infrastructure loans. And that's simply a loan from a state agency to a city, town, or county, where it says a loan from the state, usually the Division of Drinking Water or Environmental Quality issues a loan for general or specific improvements for existing systems. Many times only requiring a vote of the elected officials or board members for approval of the project and associated costs. The next is a special assessment area. We talked a little bit about this already, and that's where property owners will, in a particular area, will petition the town council, city council, whatever, to provide a service. It may be sewer service, it may be curb and gutter on the streets, it could be build a park, whatever, and they're willing to pay an additional property tax assessment for that service. And those used to be called special improvement districts. They changed the wording on them.
Probably skip the PNC road.
Okay, BNC road funds, with the exception of the diversions provided for in the Utah Code and the increased registration fees as provided in Utah Code, 30% of the state highway user taxes and fees are allocated to the Class B and Class C roads account. This is a restricted account to be used for the construction and maintenance of county roads and municipal streets that have been documented as eligible for funding according to regulations governing this fund. Only eligible centerline mileage is used to determine funding credit. That is the mileage basis for the amount of funds each local authority, i.e. city or town, whatever county, will receive. So all the towns in the state get, or all towns get some funds back from the state to go towards the maintenance of what they call municipal road.
And that's based off of the linear footage of the road, not the square footage of the road, is what that means by the center line line.
Should we go on then?
Yeah.
The property tax, everybody probably knows what a property tax is. It's a levy on the property that the owner is required to pay. The tax is levied by the governing authority of the jurisdiction in which the property is located. Franchise tax is a tax that can be placed on utility services in order for local government to be able to cover its cost and coordinating the services. And finally, a sales tax is a tax on receipts from sales usually added to the selling price by the seller. You know, we pay about, what is it, 6 and a quarter, 6.5 cents. Whatever it is. And it varies from town to town, because each town can levy a little different. But the city will get a small percentage of that comes back to them. Obviously, the majority of that stays in the state, but the city will get back
So the way that I understand that law is
some percentage of it.
is when the sales tax, 50% of the revenue from the sales tax that the city would get, the portion that the city would get, stays within the city that originated the sales tax. And the other 50% goes in a pool and then is divided out according to our census count.
Yeah, exactly right.
And so that's how sales tax is used.
That's not correct, it's 5.9 for me. Yeah.
So, Diane, to your question again, specifically on the roads, I know you guys have had some desires to pave the roads and kind of went through maybe a similar process as an SAA with the county, and that cost came in quite high.
Well, the Washington County has now passed the, I don't know what you call it, zoning law or whatever, but from last year forward, every, whether it's rural or whatever, has to have curb and gutter. And that would be similar.
And so if they were to upgrade your road, they would hold you to that standard.
Yes.
So, in annexation, I think one of the issues you guys could work out in an agreement would be, would the city be willing to sponsor an SAA at some minimum level of improvement that would allow you to either chip seal or asphalt those roads?
Yeah, that's what we want, is to be.
So, and I don't know that Leeds could do that or not according to our ordinances, but I know, in a lot of places we do not require curb and gutter. But that's something that you could work out within that annexation agreement. And the city wouldn't want that burden to fall on the existing residents. They would want that burden to remain with those who would get the benefit. And they would want to follow the city has been really good at following general obligation and specific obligation bond principles. I know when the sewer discussion came up, we held pretty firm with the state. The state wanted to come and give us a state infrastructure loan that would require anybody within 300 feet to hook onto the system. We went back and forth trying to figure out how not to do that. We raised over $700,000 in commitments from the developers. Our phase one needed about $1.5 million. We went to the state to see if they could make up the gap. They wanted to require that. We kind of went back and forth and said we'd study it, we'd think about it, we might even do it. And we came back and said, hey, the people that have working septics should not be forced to enter onto a sewer system without their consent. So we kind of held firm with the community that needed sewer and said, we're willing to be your body politic, but you've got to follow these special obligation bond principles or an SAA and create an SAA and fund the sewer through that SAA. And if our impact fee is above and beyond what's reasonable for you to pay because you're putting in more capacity than you'll use, we'd be willing to give you a reimbursement agreement so that when others hook on, it's fair. you have a way to recuperate funds and not let freeloaders just hook onto the system. I know with state loans, it takes a lot of, it takes somebody that understands those principles to be able to allocate the monies correctly. I know there's quite a bit of frustration with over 10,000 feet of line in Silver Reef that is a specific on-site improvement that has been allocated generally for those who don't even benefit from the improvement paid for. And that's a pretty big frustration among those of us who are paying for a specific improvement that we do not benefit from. It is not a system-wide improvement. And so, while it's not a town's obligation to deal with it, I know there's a lot of citizens that have asked those of us in the town what they can do and how they can deal with it. And I think they just need to understand that principle. It's really simple. That board needs to reallocate those funds and address and zone out those people who are getting a specific improvement but having us pay for it generally, and redo their water rates and have those who are specifically getting those improvements and getting the benefit of those improvements pay for those specific improvements. And then anything that's general to all of us is more than appropriate to ask all of us to pay for. But it's inappropriate for them to have used a state loan and have everybody generally paying for certain stuff.
The fire hydrants that we increase the pressure on Main Street, those are for everybody. The mayor of town and 3 other homes down on the end of Main Street over here also had an improvement. It cost $8,000 a piece.
Yep, that project has a lot of general improvements that should be spread among a lot of people, but it has a lot of specific improvements that should not have been spread to the general public.
Well, if I may ask one other question. The people on this side of the highway, on average, pay more in taxes and property taxes to come to this town than the people down here. Does that mean you're going to divide us that way too?
The mill levy's the same, sir.
No, the amount on average that a person up there pays that goes to the town is more than what they pay down here, by quite a bit. I don't hear anybody saying that we should separate the town that way. And I don't think we should, but it sounds like you're talking that way.
No, I'm not. Don't put words in my mouth.
Well, maybe you should answer the question. I wouldn't have
The
to.
mill levy's the same. The mill levy's the same.
Percentage on the house, that's correct. But as
So-
far as the amount that's being paid out of pocket, it's more.
So it'd be similar to El Dorado Hills. They've got some road issues. And those road issues should be paid for by those who benefit from the roads. It's the same thing.
If you start separating it that way, you're going to create nothing but one big mess.
I don't,
You're going to start playing one group against another. And that's
No.
not a way to run a town.
no, if Mesa View, who I benefit from, Mesa View, I live there.
Yeah.
You have no need to drive there. It is not a system road. It is not a system road. It is a local road. It is an on-site improvement. It is not an off-site. I have no business asking you, who may live somewhere else, or anybody else who lives somewhere else, to pay for my local road. But if Mesa View was like Main Street and a system road that everybody uses, then I have, that road, everybody shares in that cost, because it's a main arterial, it's a main collector.
Is this a governmental policy that you're
But-
putting, or is this something that you think personally?
No, this is how general obligation and specific obligation bonds work. It's how
And in
municipalities,
reference to the LDWA project, how does that fit in?
it fits in very well.
In what way? Are you saying that the town didn't benefit from the project as a whole? And that certain people benefited more than others?
I'm simply stating that there are specific improvements, on-site improvements, that were not system improvements, that have been allocated generally among the whole public,
And such as?
such as Silver Reef's localized roads and the localized water lines that weren't working, that got replaced.
We've already told you that the benefits down here are major because the pressures weren't correct. You know that because that's one of the things that
And
you
I'm
use to
not
try to take
arguing
over
that
the
that
water.
should be generally paid for.
Well, how are you going to separate that? By the foot?
No, state law is pretty specific, Elliot, when it comes to what's a system-wide improvement and what is an on-site improvement. Just like a development, if, let's say, Hamilton's wanted to develop their property, there would be off-site improvements that they would need, say, to fix that main road that everybody uses, that tight S-curve. And those off-site improvements would be eligible for system credits. Or they could pay for that and they would be doing system-wide improvements that benefit more than just their project. But the second you enter the project specifically, those costs should be 100% totally locally borne by that developer
When you
and those future
annex in,
lot owners.
when you annex in property, you annex in areas, you take responsibility for the roads as a town.
Under the same principles, so
So, I mean, you're trying to divide it up now? I mean, you're telling me that the state has the responsibility for that? I mean, the state says if there's state law, you can divide it up and put that burden on specific areas?
the state law requires you
In your interpretation.
No, I understand the law very well, Pat.
That's, yeah, in your
State-
interpretation.
state
Your
law-
interpretation is not always correct.
Well, it is true that I make plenty of mistakes, so you don't need to make stuff up when you run around spreading half-truths, Peter. So, I mean,
Half-truths?
you can deal.
Jared,
We're
Jared,
asking,
you
we're
guys
just
are
asking a
kidding
couple
me.
of, I'm sorry I interrupted you, but you made a comment that, I mean, I'm president of LDWA.
Sure.
And I'm just wondering if we fix 3 homes down here, do we charge them separate too?
So the specific issues, you go through your system. Like if El Dorado Hills wants road upgrades, we have this tool called an SAA. And the SAA allows us to say, okay, who benefits from these road improvements? And whoever benefits from the road improvements, pays for the road improvements. And that's the fair way to do it, just like we did sewer. We did not want to force people to sign up for sewer
Sure you did.
that did not, no I didn't, or we would have had sewer.
You were sitting right there at the end chair. I was sitting right here and heard you say that you would require that everyone
That is what.
tie into the sewer in the whole town.
That's what-
Everyone would be required.
That is not accurate, Peter. That's what the state requires when you use a state infrastructure loan. And we went out of our way to stay away from that and even raised over $100,000 from the development community and said, if you want sewer, you're not going to burden existing residents on septic. And you need to be willing to pay for the studies and be willing to fund the sewer improvements, just like a specific obligation bond. We followed those principles to a T and said, if you want the specific improvement, those who benefit from it and need it need to pay for it, not those who don't need it. And so the same thing happens in state law. That's why we have SAAs and other things, so that you can break the specific improvements and be fair down to those who actually need them. And so that's why we brought it up, because there's some confusion in town as to how special assessment areas might work, or general obligation, or specific obligation. So there's system-wide improvements that are involved in an impact fee, and then there's specific on-site improvements. On-site improvements should be paid for by those who benefit from the service. And a system-wide improvement is also paid for by those who benefit from the service, because everybody benefits from the system improvement. And so when a project comes in, it should be divided up between system improvements and on-site improvements. And on-site improvements should be localized to those who are locally benefiting. System-wide should be paid for by everybody because they benefit everybody. Specifically what items, or however that works, it needs to be addressed, and it needs to be addressed with every project. Currently, Leeds, when El Dorado Hills came into Leeds in that annexation, they asked Leeds to lower their mill levy. So they asked Leeds to take on additional services and additional liabilities, but lower their mill levy, lowering their ability to have an operating budget. For whatever reason in Leeds, for years, we have chosen not to charge ourselves the infrastructure costs that would be allocated, say, to a road. So if a road has a 30-year lifespan, we do not replace that capital account every year. We don't do it. We're living on a credit card. We don't charge enough in property taxes. So every year, we use up 1 year's life of the road. We do not replace that in a capital account because we simply don't charge enough in property taxes. And that's what we've chosen to do. So what are our choices when we go to needing a new road? Well, the choice is that we have to pass some sort of bond or get some sort of funding. And so when we use up the life of a certain road, we have to go out and get that funding. When we get that kind of funding, we need to localize the cost fairly to those who benefit from it. And if it's a general road or an arterial road or a collector road, that's everybody who benefits from that collector road. If it's a local street, it's those who are on that local street. Mesa View is kind of a cul-de-sac, it's a dead end. It's not a system-wide road. And so, I've lived in the house for 7 years, I've used up 7 years of the life. My predecessors used up 20 years of the life. Say in 3 years, the life of that road's over. Is it fair to ask other people to pay for that road? No, it's not. It needs to be borne, the cost should be borne by those who benefit. So in Leeds, one of the reasons we went over this is to deal with that concern of, hey, the roads are crumbling, who's gonna pay for this? Well, the short answer is those who benefit from it. And here's the tools by which we could do it. We could pass a general obligation bond for our system-wide roads. We could do a specific obligation bond. We could use an SAA and localize a certain area and say this is our cost and do the improvement. And so that's how that works. And that's how it needs to work in order to be fair. Yes.
I'm just gonna mention something here that I find interesting. I know that you used to be on the town council. But the items that you're discussing right now have absolutely nothing to do with your planning commission, because they're budget-oriented, and budget-oriented items are for the town council. Your role is a planning commission, and planning commission deals with land use, subdivisions, and that's about it.
Can I make a comment? This has turned into a public hearing and it really shouldn't be, should it?
I apologize for that. That's my fault.
Thank you.
I won't.
So back to the agenda and just to address the last concern. We, as a planning commission, you're right, we do deal with land use. But these different tools and these different items, we need to know about so that we can appropriately deal with people when they come in and know what those processes are as we entertain land use application. Are there any other items on number 12 to discuss?